I'm Christopher Assaro, president of Whole Construction. I'm proud to announce that the Port Authority of New York and New Jersey, in partnership with American Airlines, URW Airports, has announced a $125 million commercial redevelopment of JFK's Terminal 8. As the project's construction partner, Whole Construction is pleased to partner with URW to introduce our new information and technical assistance program designed to connect you to opportunities available across the 24-month redevelopment of Terminal 8, all part of the Port Authority's $19 billion airport redevelopment program that is transforming New York's airport system. Working with our partners at the Port Authority, American Airlines, URW, and Phoenix Infrastructure, we have designed a special series of programs that will help you learn more about the project, the business and contracting opportunities that are right for your company, and how your business can participate. Thank you for joining us, and we look forward to partnering together.
Hello, and welcome to our session on understanding contracts. Construction contracts are complex. This session will review the basics of construction contracts and focus on select provisions that affect the performance on a project, such as changes in schedule, scope, and other project elements that may impact your successful completion of a project. Learn how to properly read a contract and how to best frame the questions you might have about the contract's provisions and requirements. While many provisions are non-negotiable, you may have the option to discuss a contract requirement and work with the prime contractor and/or a Tier 1 subcontractor to address specific issues that may be related to your bid, as well as the final contract award. Now, let me introduce our panelists. Gregory.
Hello, I'm Greg Chertoff. I'm a co-managing partner of Pekar and Abramson's New York office. I'm a construction lawyer specializing in representing contractors in construction disputes for about 30 years.
Great, thank you so much. So now let's dive into some best practices. So Gregory, in your experience, what's the most common challenges subcontractors face when interpreting and complying with contract language, and what proactive measures can be taken to address these challenges?
Sure. So in an overarching sense, it's not really understanding what all the terms of the contracts that they may enter into mean and how to implement and preserve their rights. So it's critical for any party entering into a contract, whether it be an owner, a prime contractor, a subcontractor of any tier, or any party doing business in construction or otherwise. If they're entering into a contract, every provision of that contract has meaning and will be interpreted by a court, if you get to a court, because there's a dispute, to have meaning. So a complete and correct understanding of all the contract provisions, the rights, the obligations, the legal exposures, how to go about operationally preserving and protecting your rights, including giving notice, how to document claims or status. These are all critical components of contracts and critical things that any party, including a subcontractor, should really have a mastery of before they put pen to paper and sign it.
Okay, so let's dive into some best practices. So Greg, in your experience, what are the most common challenges subcontractors face when interpreting and complying with contract language? And what are proactive measures that can be taken to address these challenges?
So the first overarching challenge that we see routinely is that parties don't truly understand completely and correctly all the provisions and the import of the provisions of the contracts that they're entering into. So that may seem elemental, but it is really the first baseline of best practices. Know what you're signing, understand your business deal in both with respect to its commercial implications, cost, schedule, scope of work, but also as to the full gamut of all the other legal implications and obligations that you're undertaking when you enter into a contract, how you're supposed to perform, the processes that the contract lays out for submission of payment applications and what documentation may be required associated with that, how to give notice and preserve your rights and your how to discharge your obligations properly. So a true in-depth holistic understanding of the contract is the first and most elemental thing.
Wonderful. So when reviewing a construction contract, what role does clarity play in understanding project expectations? And how can contractors seek clarification on ambiguous or unclear provisions? Specifically, how to apply a contract provision to a specific situation?
Sure. So clarity is paramount, right? A true meeting of the minds where both parties to the agreement understand what the business deal is critical to successful project implementation, right? If party A has a different expectation than party B, that's a recipe for disaster. So really understanding and making sure that the contract documents accurately reflect the business deal is the first critical element. How to seek clarification if something is ambiguous. Well, during the pre-contract stage, there's often an opportunity to issue requests for information or seek clarity about provisions of contract terms, and everybody should take advantage of that. They should be scrutinizing the agreement, making sure they understand it. If there's any ambiguity or question, ask a written question and seek a written response prior to entering into the contract, so then that issue can be clarified. If once you enter into a contract, there's a provision that you come across that you didn't previously notice and clarify that you now think is unclear, and if it's an issue of significance, you should really be forming an opinion as to how you believe it should be interpreted and implemented, and then engaging with your contract counterparty to clarify that in writing, that this is the mutual understanding and how both parties are going to proceed. And that could come up in a wide variety of specific circumstances. So just, in many, but just by way of example, if it's unclear as to how to give a notice or to preserve a right, or what the timing of a particular milestone in a contract is, those are all critical things. And if there's any lack of clarity, you should first form your own belief and then strategize on how to get the counterparty to commit to their understanding, hopefully a mutual one, and document that so both parties have a clear frame of reference as to how they should proceed.
Great. Now, can you summarize some of the important parts of the contract?
Well, sure, and every part really is important. As I might have said before, if two parties to a contract get in some sort of dispute and they're going to wind up before a judge or an arbitrator or a mediator in an informal session, the judge or the arbitrator is going to try to give every provision of that contract meaning. That's a fundamental concept of contractual interpretation. So, but certain provisions we as lawyers look at immediately, right? When a client comes to us, we don't tend to focus on the business terms. What's the price? What's the schedule? What's the scope of the work? The clients tend to manage those things. What they look to us most typically for are things like indemnity provisions. An indemnity provision is a very important contractual provision for lawyers to look at. What an indemnity is a promise to protect somebody else from a bad consequence. So the indemnity provisions in a contract where one party may be indemnifying the other in the event of personal injury or property damage, or be exposed to damages as a consequence of the breach of the contract. Those are critical clauses we look at. Clarity as to the payment terms, right? Everybody's entering into these contracts for a purpose of making a profit and getting paid reasonably for the work that they do, and understanding what the payment terms and the process to effect and implement payment, those are critical. Understanding what happens if you don't fully comply with your contractual obligations, what your damages exposures are, and whether there's any limits to your damages exposure, caps or liquidated damages or other negotiated terms that may limit or unlimit the scope of your exposure in the event that your company doesn't properly perform. Those are critical provisions to look at. Notice provisions. What do you need to do if you claim that your ability to perform is being impaired by the contract counterparty? If a designer isn't delivering proper design information, or an owner isn't giving you access to the project site, or the course of your performance is different than what you anticipated and it's costing you more money or impeding your ability to perform timely. How to preserve all those rights and to give notice compliant with the contract to the contract counterparties so you could preserve those rights. All very critical contract provisions. And of course, there are many others, but that's a high-level summary.
Right. Can you share some successful examples between a subcontractor and a prime contractor in addressing specific contract issues, and how these collaborations contributed to the overall success of the project?
Sure. And again, the answers to this could number in the hundreds of circumstances or the thousands of circumstances, but to just give some key timely examples. As a few years ago, when COVID and the pandemic hit the world and the construction industry, and as supply chains got disrupted and materials became scarce and more expensive and longer lead items than ever before, it was remarkable from my perspective to see how the industry collaborated to address these issues: material price escalations, labor shortages, material unavailability. There was a real period of time there where owners were understanding that regardless of what the letter of their contracts might have said, there were real challenges that nobody anticipated before, and that a fair way to address these issues needed to be developed among the parties to the construction projects, or the projects would fail. And so as an outgrowth of that, we now see in new contracts that are being entered into, parties being deliberate to talk about upfront, well, what is going to happen if material prices escalate or de-escalate as market forces change, or they become scarcer, and how are the parties going to deal with that? And that's a recent, very real world example that came up again and again and again throughout contracts across the industry, and how the parties have adjusted the way they interact and their contractual negotiations based on those unprecedented market forces. Wasn't always successful. There's still disputes out of those issues, but it was really remarkable to see how the industry kind of wrestled with those issues in real time and landed at, by and large, fair landing points.
Well, one of the positive impacts of COVID, I guess, from there.
Yeah.
What should a company be looking for in a contract once they've been awarded?
Well, but even before, I'll step back, even before the award, often they'll have a form of the contract to look at with the bid materials, not always, but so that's really the time they should first be looking to understand what the form of contract from their contract counterparty if it says, and what it requires in terms of all the different things we've spoken about. And then once you're awarded, you should be revisiting all those contract terms. You may have an opportunity to try to negotiate provisions once you've been awarded and you're in a negotiation or a clarification period about certain contract terms. And then once you've landed on the final form of contract, and of course you're ready to put pen to paper and sign it, a real in detail understanding of what all those contract requirements are and the processes that you need to employ to comply with your contractual obligations is critical. For example, right, understanding what the schedule is and what the long lead time items are. And you're going to hear me refer to this again and again throughout this discussion, understanding what the notice obligations are, so that if you feel that something is going awry and entitles you or your company to additional compensation or additional time in which to perform, understanding what you need to do in real time to preserve those rights in accordance with your contract is paramount to success.
Great. And do you have any general tips on how our subcontractors can avoid claims?
Certainly, yes. And it keeps circling back to these key themes: knowing what you've committed to and what you're obligated to do. And then what I call operational risk management discipline. Understanding what's happening on the project and how things may be impacting your company, and preserving your rights with respect to those things. So it is not at all unusual for us to see parties perform. They may be being impacted, they may be being delayed or having additional cost impacts, but they fail to give notice as required under the contract, and they don't act promptly to let the other party or parties know what the issues are and solicit help to try to solve those problems. And they save these problems for later in the project or the end, and they fester. And then they become disputes. Dealing with things proactively in real time, complying with your contractual obligations to give notice and to document the issues, not only the issues as to who's at fault, but the damages or the schedule impacts that may be incurring. The best way to avoid a fight, in my experience, is to be prepared for the fight and to deal proactively with your contract counterparty about what's happening on the job so things can be addressed in real time to the maximum degree possible. Those are the best tips that I've learned about avoiding the big fight at the end.
That's great. That's super helpful. Can you explain the different services a construction attorney provides and how one can find the right construction attorney for their company, and also help us understand the role a construction attorney plays as opposed to a personal or general business attorney?
Sure. Those of us who specialize in representing participants in construction projects help manage the transactional parts up front, understanding the contracts, negotiating the contracts. We support our clients in compliance. Construction has become a highly regulated industry, both in the public and the private sector. And so understanding and developing a compliance program for clients and helping them comply with all their legal obligations is also a role that construction attorneys typically play. We'll provide project support, get phone calls from clients. Something's happening. I'm uneasy about how things are going on the project. I'd like to avoid this festering into a big problem. Please, Greg, can you help me understand what the situation is and help me strategize on how to make the best of the bad situation, how to comply with my notice requirements? What should I, as the client, be thinking about now in real time when I think something's problematic, to avoid the fight or to document my position? So if we wind up in that dispute, the client, is teed up for success. And then at the tail end of the arc of services we provide are advocacy and dispute resolution proceedings, trial, litigation, arbitration, mediation, even just negotiation, how to tee up a claim or a disputed situation or a defensive one most effectively. So that's kind of the arc of typical services construction lawyers provide. The comparing how to find the right one, you had asked, it's very much like finding the right doctor. You have to be comfortable with the person or the law firm. These are going to be your trusted advisors. They should be responsive to you. You should interview them and make sure that they speak your language, right? If you go to an attorney who holds themselves out as an expert in this area, but they don't understand what CPM scheduling is, or what a change order is, or what an RFI is, you should be concerned about whether they really have the depth of expertise to support your company. And they should be first and foremost responsive. When clients are dealing with a critical issue, be it a contract negotiation or need to get a notice out, or you want your lawyer to call you back and to be timely and to be available to you. And comparing and contrasting those of us who characterize ourselves as construction lawyers from a personal attorney or a general business lawyer, again, the analogy to a doctor is apt. A general practitioner may be a terrific doctor on a broad range of health-related issues that we may have, right? They're often our first stop when when we're concerned, or to check up on our health, or we have a particular concern. But if you get into something that's very, thorny, they'll send you to a specialist, and we're the specialists. We construction lawyers who dedicate ourselves to representing parties in the built environment really understand the business interrelationships at play and what all these contract clauses mean and how our clients operate and how we could guide them in operation. So you may get perfectly great advice from your regular business attorney, but if you're really getting into deep in the weeds construction law problem, you really want a lawyer that really understands construction, and it's a complex business.
Great. And you touched on this a little bit, but what are some tips to interviewing an attorney to make sure they're right for your company?
Sure. Well, first, I'd get recommendations. Talk to your accountants, your insurance agents, your other colleagues in your industry, other businesses like yours in your industry trade organization. That they'll often have been marched down these roads before and will have recommendations for you. And that's always a good place to start, right? A personal recommendation. I've had good experience with this lawyer and these kinds of issues. You're going to really want to understand, again, confirm that they really understand the business and your business and how it operates. I would ask about their experience and possibly ask for referrals from other clients and get to know them, and don't just give short shrift to that interview process. Really speak to them and get a comfort level, and not just in the abstract. If you're calling a lawyer, it's most likely because you have a real issue in play at the moment, and pose it to them and ask them their suggestions about how, at least initially, based on the limited information you may be providing up front, their thoughts on how they would suggest you deal with that situation, and see what questions they ask and how probing they are, and whether their philosophical approach to managing that problem or giving you guidance is consistent with your company's culture. The right fit is a very important element too. There are some lawyers who are very aggressive, and others who are less aggressive, and you really want to find the lawyer that suits your temperament and your company's temperament.
Now, costs for legal services can start to add up. How can our smaller subcontractors control their costs?
Sure. Well, developing your own expertise to the maximum degree you can, educating yourself on what the key issues are that your company may be facing again and again, will help expedite things. Certainly, you may be able to get guidance and then implement things on your own to save cost. Having your files and your documentation well organized. Just like when you go to your accountant, you don't want to bring a shoebox full of random stuff, right? Because then the accountant has to sift through it. If you have your records well organized and well documented, that makes the lawyer's job more efficient and thus less costly. You may want to consider talking with an attorney about various alternative fee arrangements. Commercial business lawyers, like I am, we most typically charge our clients by the hour. But many of us will enter into different fee arrangements. So I have clients who say, I know I'm going to be calling you routinely, or my project managers or project executives are going to be calling you regularly for general guidance. And we could set up a monthly retainer for a fixed amount. So you have predictability as to what your costs may be, and we'll cover all the normal kind of on the fly counseling under that, up to a limited number of hours perhaps, or a time period, or to readjust over time as we see what the usage is, and to make sure it's fair to both parties, lawyer and client, and asking for budgets. So there's greater predictability, and asking the lawyer, what could I, as the client, be doing to make your job more efficient and thus less costly? Those are all great conversations for clients to be having.
Great. And now, how should a company use their attorney? If a problem arises, should they reach out to the attorney immediately or try to resolve it on their own first?
I'll give everybody's favorite lawyer answer here, which is it depends. It's really a critical judgment call that the client needs to make. Of course, as the lawyer, I always like to get called earlier rather than later, because like the old analogy goes about steering a massive ship, right? Small corrections early are easier than big corrections later on. But you have to use your judgment. If it's a minor issue or you don't think it's going to become a major issue, maybe those are ones you handle yourself. But if you get a concern that this may blow up to something larger or more contentious or more complicated, then I would suggest the default should be reaching out sooner for the small bit of guidance rather than letting the situation fester. I often regret for my clients that they hadn't called me earlier for a 15-minute phone call to brainstorm about how to strategize something, and now we're in a big dispute that perhaps could have been avoided.
Now, small subcontractors often have an accountant and an insurance broker. How can they integrate these professionals to help them avoid claims?
Sure. Well, as I mentioned before, these are great resources for legal referrals. Because accounting firms and insurance brokerages or agencies often interact as professionals with the other professionals, lawyers that clients use. And depending on the nature of the matter, all three disciplines, accounting, insurance, and legal, may be integrating their expertise to serve a client simultaneously on one issue. So by way of example, if there's an issue on a project where there's a collapse or a fire or something else goes wrong, right? You're going to want to reach out to your insurance agent right away and let them know these are the things that happen, and use them as the first guide to triage, well, what insurance policies may exist, not just within your company, but that the other project participants may have, that could potentially respond to this kind of incident. And let's make sure everybody's on notice. So your insurance agent may be the first stop there, but you may also be speaking with your attorney at the same time about these issues. And the two professionals may be collaborating on how to guide that effort. If you're tracking your damages, because you're entitled to a change order or because a delay has occurred and you're making a claim, well, tracking cost, of course, is critical to that exercise. So you may have internal resources that are very skilled at doing that, or you may want to reach out to your accounting firm for guidance and a collaborative effort on how to assist in making that real-time record of documenting what your costs are. So if and when you have to prove your claim, you have that information already available, and it's much easier to document things with discipline in real time than it is to go back after the fact and try to mine the data and recreate it or have an expert do it. So those are just a handful of ways that these various professional disciplines interact to give collaborative guidance to clients.
Many firms have an in-house contract manager. How can those roles help the project team avoid claims on a project?
Sure. Well, those people are typically trained to really dive into the contract, understand its terms, understand not only the commercial terms of those contracts, but also the notice provisions and the documentation provisions, which you hear me keep coming back to. Those are critical. So having skilled people in-house that aren't necessarily a part of the day-to-day project team and maybe are a little more objective and one step removed can often be great internal resources for helping identify contract processes that should be respected, for helping draft notice letters in a collaborative and productive and non-confrontational tone and way, and for taking some of the burden of dealing with all these challenges away from the project team, who already has a more than full-time job typically in getting the job built and managing the process. So people with that kind of commercial contract management expertise are often incredibly valuable resources when we see our client companies use them effectively. And that is also, going back to another question earlier, a great way to try to manage the legal spend by having somebody skilled and disciplined internally that could shoulder at least some of that burden.
Wonderful. Thank you so much, Greg. This has been extremely informative. And now we're going to see if our audience has any questions for us. everyone, and welcome to our live Q&A. So we're going to get started with some questions here. So the first one I'm going to take, because I think this is specific to Holt, but is there someone who could walk me through the contract and answer questions I might have? So if you get a subcontract issued to you from Holt, or for that matter, any GC really, the best thing to do would be to contact the contracts department, the person who sent you the contract, and they'll be able to walk through some stuff with you. And in the case of Holt, for example, our contracts department might walk through some of the terms with you, but then for anything job specific, they might pass you off to the project manager to walk through some of those intricacies with you. Will the full scope of work be outlined in the contract or just the scope my company is working on? So for Holt, we'll just put your specific scope in the contract. So it'll have milestones, clarifications, things like that that have to do with your specific scope of work. We will also give you access to our owner contract, redacted, of course, so you'll be able to see the full scope of work outlined overall. But for your contract, it'll just be your scope of work. Okay, another question I think directed at Holt is the construction schedule outlined in the contract? What happens if my company isn't able to meet the deadline on schedule? So at Holt and a lot of other GCs will include milestones in your contract. So the flow of dates or the amount of time that you have to complete the work. Some other GCs might include a copy of the schedule or milestones as well. If you're not able to complete your scope of work by the deadlines on the schedule, this goes for Holt or any other GCs, you're going to want to have that conversation with your project manager and the superintendent. Let them know where you're having issues, is there delay on materials, things like that, so they can then discuss that with the owner and everyone's on the same page. The best thing to do, as you heard from the presentation, is keep everyone up to date on what's going on so we can figure out a way to work with those issues. What happens if there is a delay on a portion of the project, such as supply chain issues or not enough workers? Will my company be penalized for these delays? I would say as far as Holt goes or other GCs, you're gonna, just like the previous question, you're gonna want to keep in contact with your project managers on those sorts of things. You won't necessarily be penalized, but if you're not keeping the person up to date or the project manager up to date on what those issues are, and all of a sudden you're just, don't show up to work with enough workers, that's going to be a problem on site. And we'll do this last one here. What did the pre-approval with Holt, DOT, and JFK? How do we access how to bid? So for this specific project, what you're going to do is just keep watching these sessions. The bid list is going to come out soon. And then we're going to go ahead and issue out bids through Building Connected for each of the scope of work. So that you're going to find out in that way. Then the next part of that is for the retail, the concession part of work, we will start doing sessions later on in the next few months with the specific retail, with the specific questionnaires, with the concessionaires, and there'll be different bids for each of those, and those will be laid out, the schedule and that sort of thing. Mark, just to make sure I answered the previous one correctly, how do you perceive, like, if there's a delay on the project, such as supply chain issues or not enough workers, how should a subcontractor handle that sort of issue that they might have?
Sure. So it goes back to things that Greg Chertoff had been talking about beforehand. It depends. You have to review your subcontract to see what type of notice you have to give. You have to review your subcontract to see what type of relief you might have. And most importantly would be to find an attorney to help you review those and see, whether or not you have the basis to ask for additional compensation for delays, or, in the converse, whether or not you might be liable to some sort of damages if that was within your control. So it really depends on the circumstances and the specific language of your contract.
Great, thank you. One more question here. How can I find out what project manager specific for my trade? So with Holt, you're going to have one project manager on the project. You might have a senior PM, a PM, an APM, but they're going to work with all of the trades on the project. So when you're bidding, you'll obviously be in contact with an estimator. If you're awarded work, the project manager will reach out to you, and then you'll know to communicate with them. And that's all the questions we have. So thank you, Mark, for joining us for the live Q&A. Really appreciate it. Next week, we have Understanding Insurance. And the week after that is what to do if you didn't successfully pre-qualify. So please sign up for those sessions. And as always, any other questions, concerns, go to the new jfk.com, the website. We'll have all the information you can need. Thank you, everyone. Have a good day.
Take care, everybody.